Okay, welcome everyone to the bonus materials for our ADA Law and Lawsuits class. And in these bonus materials, what I'm really going to do is I've picked out a sampling of real lawsuits, a real answer to a lawsuit of the different types and kinds that we've been discussing. And we're just going to kind of go through them and I'm going to show and explain exactly what in the real world these cases look like when they're served, how they're drafted, and the logic of the allegations in the complaint, which should make a lot more sense to anyone who's viewed the actual body of our class here than it would have made before taking the class. So here's a case I took from the Southern District of New York. In all of these cases, I have redacted out the actual parties' names and case numbers because I don't want to personalize this or make this about anybody specific. I just want to talk generally about what these lawsuits, what the actual lawsuit papers and responses look like. Okay, so this is a complaint, otherwise known as a lawsuit. This is the first document that's served on the defendant when a lawsuit is initiated. This is what the plaintiff will file with the court. The clerk of court will stamp on a case number, which is what's blurred out up here. The case number will then be written here moving forward. And the names of the parties will be here, the plaintiff, the defendant. And then this document will ultimately be served on the defendant. So here the plaintiff, whatever their name is, sues the defendant for injunctive relief, right? Which, as we know, is what the ADA provides for. Attorney's fees, which, as we know, is what the ADA provides for, and costs. Including but not limited to disbursements, court expenses, and fees pursuant to 42 U.S.C. Section 102.181 et sec, the Americans with Disabilities Act, or ADA, and the ADA Accessibility Guidelines, which is 28 CFR Part 36, and by now everybody's familiar with what all that means. And then this goes on to also say that there's some claims under New York City law because it's a New York case. But in any event, that is the first page. Let's see. So paragraph 8. Let me skip down to that. Pardon me. Let's skip down to paragraph 8, and we see actually paragraph 5. So plaintiff has at all times suffered from a qualified disability under the ADA. As a result of a spinal cord injury, plaintiff suffers from paraplegia. Obviously, a qualified disability under the ADA. We read the ADA definition of disability, and paraplegia would certainly qualify. The defendant, a New York limited liability company, owns and operates that certain real property located at whatever the address is, a place of public accommodation known as whatever the business name is, which is located upon the subject property. And then here we have the landlord. So this is the tenant that's running the property, right? And now here we have the landlord, which owns and operates that certain public accommodation, and it identifies what it is. Prior to the commencement of this action, plaintiff personally visited the subject property but was denied full access to the facilities at the subject property and or any accommodations offered to the public therein. Let's see, plaintiff remains unable to visit and make use of the property and continues to be discriminated against and thus injured by architectural barriers to access that remain at the subject property in violation of the ADA. Okay. Plaintiff intends to return to the property after an injunction is issued and after compliance by the defendant therewith, in order to avail himself of the goods and services offered to the public therein. So we've established an ADA case here. We have or the plaintiff in this case there is a disabled plaintiff, there is a place of public accommodation, the tenant and the landlord are sued, the plaintiff visited but wasn't able to gain full access because of unlawful barriers and is asking for an injunction for removal of those barriers so that he can use the place of public accommodation. Down here, the subject property is legally required to be, but is not in compliance with the ADA. And then here's a list of the alleged non-compliance: non-compliant ramp, non-compliant ramp slope, uneven floor surface, non-compliant cross slope, non-compliant required minimum maneuvering clearance, etc., etc. Okay. Plaintiff intends to visit the property again in the future upon defendant's compliance. As a result of the foregoing, defendants have discriminated against plaintiff and will continue to discriminate against plaintiff unless and until it is compelled by this court to remove all physical barriers upon the subject property. And then we have what's known as the wherefore clause, which is how every complaint ends, which asks for, which includes the prayer for relief, or what exactly the plaintiff wants. In this case, injunctive and declaratory relief. Declaratory relief is where a court simply declares a state of fact. So the plaintiff wants an injunction and declaratory relief, declaring that the property is owned and controlled by the defendants in violation of the ADA, requiring that the defendants evaluate and neutralize their policies, practices, and procedures toward disabled individuals, requiring them to alter their facilities and amenities to make them accessible and usable by individuals with disabilities, a permanent injunction requiring them to close the subject property and cease all business until they remove violations under the ADA, whether or not the ADA provides for that. I think that's something that is frequently asked for. That's more of an equitable matter, that the defendant cease operations in a manner that's discriminatory until they comply with the ADA, and an award of attorney fees and costs in favor of the plaintiff. So that is a standard run-of-the-mill architectural barriers case. Here I've pulled up a online reservation systems case. I'm just sort of mixing it up here. I pulled one up from California. Again, the defendant owns and operates the hotel, such and such hotel, the hotel that's identified. It takes reservations through its website and provides information regarding available guest rooms and amenities. Plaintiff has at all times suffered from a qualified disability. Plaintiff is a diagnosed paraplegic and uses a wheelchair for mobility purposes. Plaintiff currently plans to a trip to Southern California, plans to be in the area for a friend's wedding. Moreover, he plans to continue to visit Southern California for other events or vacations. So here the plaintiff is establishing his standing. He's establishing that he has a reason why he wants to visit the area of the hotel and that he intends to have more reasons in the future. This explains in paragraph 14 that the ADA, the 2010 amendments, effective March 15th, 2012, impose significant new obligations on inns, motels, and hotels. And we already discussed all of this in detail, that they have to take reservations from the disabled in the same way as they do from the able-bodied. Okay, and then the plaintiff alleges the website allows reservations to be taken for the hotel online. Defendant has control over the information provided to the public about the hotel through the website or other online platforms. Plaintiff visited the website to learn about accessible features of defendant's hotel, to independently assess whether the hotel is accessible to him, and to see if he could reserve an accessible room online in furtherance of staying there if it best meets his accessibility needs during his upcoming visit. Upon visiting, he encountered all of these violations. No information regarding any of this, whether the registration desk complies with the 1991 standards, whether the meeting rooms comply with the 1991 standards, et cetera, et cetera. The website homepage also says nothing about accessibility. A menu entitled Rooms brings up a page displaying, and this just describes the ways in which this website is or was not in compliance with the ADA online reservation system requirements. And then there's the wherefore clause asking that the court enter a judgment declaring that the website is operated in violation of the ADA, entering temporary and permanent injunctive relief enjoining defendant from continuing its discriminatory practices, entering an award of compensatory damages. This is a California case, remember? So this is under California law that damages are being asked for. Entering an award of reasonable attorney fees, costs, disbursements, and such other relief as the court deems just and equitable. So this is just an example of another type of ADA lawsuit, an ORS case. And next, we will be looking at one more lawsuit. This is also from New York, and this is a website lawsuit. And this is the last lawsuit that we're going to be looking at. I mean, they all follow more or less the same pattern. So now it does say class action complaint on this one. That's an issue I don't really want to talk about very much. Class actions are obviously their own topic and very, very complicated in and of their own right. Sometimes these cases are filed as class actions. I am not aware of any ADA Title III class action that has actually been certified as a class action at any time in the past few years. That doesn't mean it hasn't happened. I'm just not aware of it. Generally speaking, though, I've been involved in a lot of cases. I've not seen a motion to certify a class. I'm not quite sure. I can't speak for anybody else or about anybody else's intentions. I'm not quite sure how serious sometimes these class action requests are, but you do sometimes see them. So here we have, let's see. So some information here about how many people in the U.S. are blind and visually impaired. Okay. Now, okay. Plaintiff was at all times a resident of New York. Plaintiff is a blind, visually impaired, handicapped person and a member of a protected class of individuals under, this is the section that we discussed that defines who is disabled, and the regulations implementing the ADA set forth at 28 CFR, Part 36. Defendant was at all times doing business in New York. Defendant's website and its goods and services offered thereon is a public accommodation within the definition of the ADA. Whether the website itself is a public accommodation or not, this is a very complex and controversial topic. There certainly are some ADA plaintiffs out there taking the position that the website itself is a public accommodation. Even without a tie to an actual physical place. Again, that's sort of a liberal understanding of what a place of public accommodation is, but until there's more guidance that's applicable all over the country, probably wise for public-facing websites to all comply. Next slide. As a result of the visiting defendant's website and from investigations performed on his behalf, plaintiff is aware that the website includes at least the following additional barriers. And now this is going over all technical issues that are apparently present on whatever website this was, or at least alleged to have been present. These barriers denied plaintiff the ability to use and enjoy defendant's website in the same way that sighted individuals do. Due to the inaccessibility of defendant's website, blind and visually impaired customers such as plaintiff who need screen readers cannot fully and equally use or enjoy the facilities defendant offers to the public. These access barriers have caused a denial of plaintiff's full and equal access in the past and now deter plaintiff on a regular basis from visiting the website presently and in the future. And now we have the prayer for relief, which again is for preliminary and permanent injunctive relief, requiring that defendants stop violating the ADA, all different versions of that, including some New York law issues here, and a prayer for attorney fees. Okay, those are complaints. If you'll notice, all the complaints that we looked at are in numbered paragraphs, and that's for organizational purposes because when a complaint is answered, the answer also is in numbered paragraphs that correspond to the number of the allegations in the complaint. So the answer will admit or deny or say something else. And I don't want to get into those details. Anybody who's sued is going to hire a lawyer who will know what needs to be said in response to each paragraph. But generally speaking, admit or deny or say something else that the lawyer feels is relevant with regard to each allegation, each numbered allegation, and then there will be affirmative defenses included within an answer. So what I want to do is walk through the affirmative defenses that were raised in this answer. And I think that hopefully for those of you who have watched the entire class, some of the issues raised as a defense, as an affirmative defense in the case, will look familiar. Now, an affirmative defense is a pleading by way of avoidance. So an affirmative defense says even if all the allegations are true, the defendant is still not liable because of this affirmative defense. For example, statute of limitations, very common affirmative defense. So if there's an allegation against a defendant and it's 100% true, but it's beyond the statute of limitations period, then the affirmative defense of statute of limitations will be an avoidance of the plaintiff's claims. But let's look at the affirmative defenses raised here. So plaintiff's claims are barred by plaintiff's lack of standing to assert the claims. Plaintiff is not a qualified individual with a disability under the ADA. Further, there is an insufficient nexus between plaintiff's alleged disability and the proposed modifications. Finally, plaintiff cannot demonstrate an immediate intent to return to the property. Whether or not that's an affirmative defense, truly, I don't know. But hopefully, after having listened to this class, anyone who listens to that phrase understands the issues that we're sort of speaking about here. Now, number two, plaintiff's claims are barred in whole or in part because plaintiff's proposed modifications are not readily achievable. Readily achievable, something we spoke about in detail. Removal of barriers in existing facilities only has to be done to the extent that it is readily achievable. Plaintiff's claims are barred in whole or in part because the proposed modifications and or steps would fundamentally alter the nature of goods and services provided. Another issue we talked about as it relates to policies and procedures or auxiliary aids and services. I don't know exactly what the case was about that this answer was done in, but as we've discussed earlier in this class, policies, procedures, auxiliary aids, and services have an exception where they will fundamentally alter the nature of the goods and services provided. And this is a similar affirmative defense that it will be an undue burden on defendant. Again, applicable in certain circumstances that was already covered earlier in this class. Modifications would result in a direct safety threat. Also, something that was discussed earlier in this class. Structurally impracticable. Also discussed earlier in this class. If you recall, the language was in those rare circumstances where the terrain or the building is such that it just can't be done. Structurally impracticable really means it's impossible. It's just it is not possible for this building or for this modification to take place, which in my view is a fairly rare circumstance. But every case stands on its own. Same thing here. Technically infeasible, right? So not technically feasible. Another issue discussed earlier on. Let's see, number 8 is not really an issue because the federal ADA doesn't require notice. Modifications demanded by plaintiff are subject to and limited by applicable local, state, or other laws such that they may not be able to be performed, assuming that such modifications would otherwise be required. That's I guess a reasonable argument that someone could make. Really this is arguing that it's not readily achievable to remove the barriers because it would be a violation of other laws, I assume. Number 10, any null violations of the ADA have been remediated or will be remediated prior to the entry of judgment. This is the mootness issue that I alluded to earlier, that in some circumstances it's possible to fix all the issues, and at least where only the federal ADA is at play and only injunctive relief is available, moot the claims. Again, a complicated issue and one really only relevant to people who have an ADA issue that they're actually an ADA litigation that they're actually dealing with, in which case they should be talking to their own lawyer about this situation. So that concludes the bonus materials. I just wanted, as a sort of extra bonus, to go through the some actual complaints and an actual answer to just give some real life context to the way these lawsuits are pursued in terms of the papers that are filed in court. But again, actual litigation of these cases, very complicated issue, and something that really requires anybody with that issue to go and seek out legal counsel in whatever jurisdiction they live in to discuss their specific situation. Another disclaimer, nothing in this entire video is specific to the situation of anybody watching this video, because I don't know anybody's specific situation, and nothing here, therefore, is legal advice in any way, shape, or form. It shouldn't be relied upon in that sense. I hope that everybody really has a much better idea now than they did 3 hours ago about what the ADA is, what ADA lawsuits are, and for those small and medium-sized business owners and all commercial property owners, and really everybody who was not aware of this issue and may be subject to these ADA Title III requirements, now at least has some foundational information, a foundational education, and some understanding of a pathway forward in terms of becoming compliant with the ADA, creating accessibility for the disabled, and avoiding being served with an ADA lawsuit, which of course is something that everyone wants to avoid. All right, thank you all very much for watching this presentation. I appreciate it.